Lawmaking. Evaluation of the mischief rule. The mischief rule of statutory interpretation is where the court seeks to find the mischief the act was aimed at when there is ambiguity in the wording of the statute. For a full explanation on the mischief rule, please see the video, The Mischief Rule of Statutory Interpretation. This video will focus on the advantages and disadvantages of the rule. Advantages of the mischief rule include: 1. It is a flexible approach. 2. It considers Parliament's intention, not just the words. 3. It avoids awkward precedents. 1. It is a flexible approach. The mischief rule avoids the harsh and often illogical results under the literal rule. It allows judges to cope with situations unforeseen by Parliament. For example, in Royal College of Nursing v DHSS, Parliament in 1967 did not envisage that surgical abortions would be largely replaced with hormonal abortions. This flexibility allows judges to develop the law to cover advances in medical science and new technologies. It also allows judges to avoid injustice, as seen in Corkery v Carpenter, where the judges were able to ensure the law prevented intoxicated people from endangering themselves by riding bicycles on the road. 2. It considers Parliament's intention, not just the words. The literal rule fails to recognize the complexities of language and allows a result which was never intended nor envisaged by Parliament. For example, it is most unlikely Parliament would have intended the outcome in R v Harris, where the defendant incurred no sanction for biting a person's nose off, or in Whiteley v Chappell, where the defendant escaped liability for using the vote of another. The mischief rule involves seeking Parliament's intention, which should produce a fairer and more practical outcome, and close loopholes. Allowing reference to Hansard in Pepper v Hart makes it easier for the courts to discover Parliament's intention. 3. It avoids awkward precedents. An application of the literal rule can lead to nonsensical results. Once an interpretation has been given by an appeal court, this sets a precedent which must be followed by all future cases. This was seen in R v Harris, Whiteley v Chappell, and DPP v Cheeseman. Such precedents require parliamentary time to make amendments and could have been avoided had the mischief rule been applied. Disadvantages of the mischief rule include: 1. Judges become lawmakers. 2. It creates uncertainty in the law. 3. Difficulty arises in determining Parliament's intention. 1. Judges become lawmakers. Judges are given too much power to develop the law, and they are thereby usurping the power of Parliament. For example, in Smith v Hughes, the law on soliciting was extended to cover those soliciting in privately owned homes. In Elliott v Gray, the law was extended to cover compulsory insurance for cars not only being used on the road but also parked on the road. Such extension of the law infringes the separation of powers. According to Montesquieu, it is Parliament's function to make the law and the judiciary's role to apply the law. Judges should not make the law, as they are unelected and not accountable. Judge-made law is undemocratic. They have no power to commission research or consult with experts or the public. Lawmaking should not be in the hands of too few with the scope for judicial bias. The scope for judicial bias can be seen in Smith v Hughes, where the judges may well have applied their own sense of morality to convict the defendants. It is quite plausible that Parliament intended to prevent prostitutes from soliciting in the street and public places for their own safety and protection, rather than to protect others from viewing them. Judicial law making in this way creates a crime after the event which infringes the rule of law. For example, in Elliott v Gray, the defendant did not think that he needed insurance for his vehicle as it wasn't being used on the road. However, the court then decided that a parked car was being used even though it was incapable of being driven. 2. It creates uncertainty in the law. By moving away from the wording of Parliament, judges create uncertainty in the law. It is difficult to predict which rule the judge is going to apply. It also encourages litigation as parties seek to enforce an alternative interpretation. Lord Mackay in Pepper v Hart highlighted how allowing reference to Hansard may lead to prolonged examination of irrelevant material by lawyers, which adds to the cost and length of litigation. Difficulties arise in deciding what was Parliament's purpose. The concept of Parliament's intention assumes Parliament has one intention. This is most unlikely since Parliament is made up of 650 MPs and around 770 Lords. It also ignores the fact that Parliament is divided on party lines. This may mean judges are forced to choose between two opposing political viewpoints, forcing judges into the political arena. For example, in Bromley v GLC, the GLC under Labour control, headed by Ken Livingstone, were under an obligation to run the London transport on economic lines. Ken Livingstone introduced a scheme to reduce pollution and congestion in London by reducing fares on tubes and buses by 25%. This was to encourage more people to use public transport rather than cars. To fund this, he put a levy on London borough councils. The Conservative-controlled Bromley Council challenged the scheme, arguing economic meant it had to be self-funding. GLC argued economic meant value for money, taking into account the value gained by lower congestion and pollution. They also pointed to the fact that the scheme was in their election manifesto and therefore they had a democratic mandate to introduce the scheme. However, the House of Lords held for the Conservative Bromley Council, holding that GLC was in breach of its fiduciary duty to ratepayers and that the judiciary are not bound by the wishes of the electorate. In summary, the mischief rule is flexible. It considers Parliament's intention rather than just the words, closes loopholes and avoids awkward precedents. However, it does allow judicial law-making, creates uncertainty in the law and can give rise to difficulties in what amounts to Parliament's intention. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/@e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.elawrevision.org.uk for revision games and quizzes. Thanks for watching.